This presentation is a summary on credit transactions. It will tackle four parts, namely pledge, chattel mortgage, real mortgage, and antichresis.
Pledge is a contract by virtue of which the debtor delivers to the creditor or to a third person a movable or document evidencing incorporeal rights for the purpose of securing the fulfillment of a principal obligation with the understanding that when the obligation is fulfilled, the thing delivered shall be returned with all its fruits and accessions. Pledge validity depends on the validity of the obligation secured by the pledge. There are two parties in pledge, namely, the pledger and the pledgee. The pledger is a natural person or legal entity that has right of ownership to the pledged asset. Both the obliger of a secured obligation and a third party may be a pledger. Assets in common ownership may only be pledged by consent of all co-owners. Commercial companies and enterprises pledge their assets in conformity with their incorporation documents. A share of assets in common shared ownership may be pledged without the other co-owner's consent. Assets owned by persons with limited ability to perform and minors may only be pledged by the consent of their guardianship or custody authority. The pledge is an entity for the benefit of which a pledge is established. The different types of pledge. Pledge is established with regard to a movable or real asset or a body of movable or real assets. Pledge of real assets is called mortgage. Movable assets are encumbered with pledge with or without their disposition. Pledge of a movable asset with its disposition is called pawn. Indivisible pledge. Pledge will be indivisible even if the pledged asset or obligation is divisible. Therefore, the debtor's heir who has paid a part of the debt cannot ask for the proportionate extinguishment of the pledge or mortgage as long as the debt is not completely satisfied. Neither can the creditor's heir who received his share of the debt return the pledge or cancel the mortgage to the prejudice of the other heirs who have not been paid. Exceptions to the rule of indivisibility. First, where each one of several things guarantees determinate portions of credit. Second, where only a portion of the loan was released. Third, where there was failure of consideration. And fourth, where there is no debtor or creditor relationship.
Requisites to a contract of pledge. It be constituted to secure the fulfillment of a principal obligation. The pledger be the absolute owner of the thing pledged. That the persons constituting the pledge have the free disposal of the property and in the absence thereof that they be legally authorized for the purpose. The pledge is perfected by the delivery of the thing pledged. When the principal obligation becomes due, the things which the pledge consists may be alienated for the payment of the creditor. Characteristics of a contract of pledge. Real contract. Perfected by the delivery of the things pledged by the debtor who is called the pledger to the creditor who is called the pledgee, or to a third person by common agreement. Accessory contract. Unilateral contract. Subsidiary contract. What is the cause or consideration in pledge? Pledge is an accessory contract. Its cause is the principal obligation, constituted to secure the fulfillment of the principal obligation, constituted by the absolute owner. Future property cannot be the subject of a pledge or mortgage. A pledge or mortgage executed by one who is not the owner of the property pledge or mortgage is without legal existence and registration, cannot validate it. Share in a co-ownership shall be limited to the portion which may be alienated by him in the division upon the termination of the co-ownership. What is the absolute owner? It means unencumbered property. The absolute owner has legal and beneficial ownership. Thing pledge or mortgage may be alienated, necessarily implied as an inherent element of the transaction of the mortgage or pledge. The only remedy for the pledgee is to have the security given sold at public auction, and the proceeds of the sale shall be applied to the payment of the obligation secured by the mortgage or pledge. Rights of creditor where debtor fails to comply with his obligation in pledge. If the debtor fails to comply with the obligation at the time it falls due, the creditor is merely entitled to move for the sale of the thing pledged. The creditor cannot appropriate himself without foreclosure. The thing pledged is pledged or under mortgage, nor can he dispose the same as owner. Risk of loss of property pledged or mortgaged. Debtor owner bears the loss of the property. The principal obligation is not extinguished upon the loss of the thing pledged or mortgaged.
Illustrative example of pledge. Romeo asks to borrow 500 from Juliet. Juliet decides first that Romeo will have to pledge the mask he used at the masquerade ball, a security that he will repay the debt by a specific time. Explanation. Romeo is called the pledger and Juliet the pledgee. The mask is referred to as the pledged property. As in any common pledge contract, possession of the pledged property is transferred to the pledgee. At the same time, however, ownership of the pledged property remains with the pledger. Romeo gives the mask to Juliet, but he still legally owns it. If Romeo repays the debt under the contractual agreement, Juliet must return the mask, but if he fails to pay, she can sell it to satisfy his debt.
What is a chattel mortgage? A chattel mortgage, as defined by Article 2140, is a contract by virtue of which a personal property is recorded in the chattel mortgage register as a security for the performance of an obligation. If the movable, instead of being recorded, is delivered to the creditor or a third person, the contract is a pledge and not a chattel mortgage. So the following are the three characteristics of chattel mortgage. First, accessory contract. It is for the purpose of securing the performance of a principal obligation. Second, formal contract. For its validity, registration in the chattel mortgage register is indispensable. Third, unilateral contract. It produces only an obligation on the part of the creditor to free the things from the encumbrance on fulfillment of the obligation. So now let us talk about the differences of chattel mortgage and pledge. Chattel mortgage and pledge has 5 distinctions. First, in chattel mortgage, the delivery of the personal property is not necessary, while in pledge, such delivery is necessary. Second, in chattel mortgage, the registration of the personal property in the chattel mortgage register is required by law, while in pledge, registration on the registry of property is not necessary. Third, in chattel mortgage, the procedure for the sale of the thing given as a security is found in Section 14 of Article number 1508, while in pledge, the procedure is found in Article 2112 of the Civil Code. Fourth, in chattel mortgage, if the property is foreclosed, the excess over the amount due goes to the debtor, while in pledge, if the property is sold, the debtor is not entitled to the excess unless it is otherwise agreed or exempt in the case of legal pledge. Fifth, in chattel mortgage, if the property is foreclosed and there is a deficiency, the creditor is entitled to recover the deficiency from the debtor, except if the chattel mortgage is a security for the purchase of personal property in installments. In pledge, if the property is sold and there is a deficiency, the creditor is not entitled to recover the deficiency, notwithstanding stipulation to the contrary. Now that you can distinguish chattel mortgage from pledge, let us now talk about their similarities. First, both are executed to secure performance of principal obligation. Second, both are constituted only on personal property. Third, both are indivisible. Fourth, both constitute a lien on the property. Fifth, in both cases, the creditor cannot appropriate the property to himself in payment of the debt. Sixth, in both cases, when the debtor defaults, the property must be sold for the payment of the creditor. Seventh, both are extinguished by the fulfillment of the principal or the destruction of the property, or the destruction of the property pledged or mortgaged. There are offenses involving chattel mortgage. First, under the revised penal code, These two acts are punishable. A. Knowingly removing any personal property mortgaged under the chattel mortgage law to any province or city other than the one in which it was located at the time of execution of the mortgage, without the written consent of the mortgagee. And B. Selling or pledging personal property already pledged, or any part thereof, under the terms of the chattel mortgage law, without the consent of the mortgagee, written on the back of the mortgagee and duly recorded in the chattel mortgage register. Second, an essential element common to the two acts punished under Article 319 of the Revised Penal Code mentioned previously as that the property removed or pledged, as the case may be, should be the same or identical property that was mortgaged or pledged before such removal or pledging. Applicability of provisions on pledge. The provisions of the Civil Code on pledge shall apply to a chattel mortgage only insofar as they are not in conflict with any provision of the chattel mortgage law. Otherwise, the provisions of the latter will apply. The subject matter of a chattel mortgage must always be personal or movable property. Creation of a chattel mortgage. There is only one way for executing a valid chattel mortgage. It is through the registration of personal property in the chattel mortgage register as a security for the performance of the obligation. If the property is situated in a place different from where the mortgagor resides, it needs to be registered in the area of the residence of the mortgagor and in the area where the property is situated. Affidavit of good faith required. An affidavit of good faith is an oath wherein it is stated that the chattel mortgage has been constituted to secure a principal obligation and not meant for fraud or any ill purpose. A good chattel mortgage includes the requirement of an affidavit of good faith appended to the mortgage and recorded therewith. But the absence of the affidavit vitiates only as against third persons without notice, like creditors and subsequent encumbrances. Applications of proceeds of sale. As mentioned earlier, when the debtor defaults, the property must be sold for the payment of the creditor. The proceeds of the sale are to be applied to the payment of the first, costs and expenses of keeping and sale. Second, payment of the obligation secured by the mortgage. Third, claims of persons holding subsequent mortgages in their order. And fourth, the balance, if any, shall be paid to the mortgagor or person holding under him. Right of redemption. When the condition of a chattel mortgage is broken, the mortgagor, a person holding a subsequent mortgage, or a subsequent attaching creditor may redeem. An attaching creditor who so redeems shall be subrogated to the rights of the mortgagee and entitled to foreclose the mortgage in the same manner that the mortgagee could foreclose it. The redemption is made by paying or delivering to the mortgagee the amount due on such mortgage and the costs and expenses incurred by such breach of condition before the sale thereof.
Real mortgage.
What is mortgage? Mortgage, also known as real estate mortgage or real mortgage, is a contract whereby the debtor secures to the creditor the fulfillment of a principal obligation, especially subjecting to such security immovable property or real rights over immovable property in case the principal obligation is not complied with at the time stipulated. Requisites of a real mortgage are that it be constituted to secure the fulfillment of a principal obligation, that the mortgagor be the absolute owner of the mortgage, that the person constituting the mortgage must have the free disposal of his property, and in the absence thereof, that he be legally authorized for the purpose, and lastly, that the document in which the mortgage appears be recorded in the registry of property. Important characteristics of real mortgage. Accessory, cannot exist without a principal obligation. Indivisible, creates a lien on the whole or all of the property's mortgage, which lien continues until the obligation it secures has been fully paid. Inseparable, it subjects the property upon which it is imposed, whoever the possessor may be, to the fulfillment of the obligation for whose security it was constituted.
Real right creates a lien on the property mortgage whereby the mortgage has a right to have the mortgage property sold to satisfy his claim. Real property, a real right over immovable property. Objects of real mortgage are immovables and alienable real rights in accordance with the laws imposed upon immovables. Kinds of real mortgage. There are three kinds of real mortgage. First is conventional or voluntary, one created by the agreement of the parties or constituted by the will of the owner of the property on which it is created. Second is legal, one required by the law to be executed in favor of certain persons. Third is equitable, one shows the intention of the parties to make the property as a security for a debt. Extent of real mortgage. A contract of real mortgage shall cover the following: the property mortgage, natural accessions, improvements, growing fruits, rents and income not yet received when the obligation becomes due, indemnity granted or owing to the proprietor from the insurers of the property mortgage or in virtue of expropriations for public use.
Form of real mortgage between the parties. The real mortgage may be in any form since it is a consensual contract. The contract is binding between the parties even if it's not registered in the registry of property. However, since a real mortgage creates a real right, the same must be in a public instrument for the convenience of the parties. The person whose favor the law establish a mortgage have no other right than to demand the execution and the recording of the document in which the mortgage is formalized. Form of real mortgage as regards third persons. The real mortgage must be recorded in the registry of property. However, the real mortgage is nevertheless binding against third persons who have knowledge of the same. Stipulation prohibiting alienation and second mortgage. A stipulation forbidding the owner from alienating the immovable mortgage shall be void. The mortgager, being the owner of the property mortgaged, may execute a second mortgage thereon even without the consent of the mortgagee. This is an incident of ownership. Foreclosure is the remedy available to the mortgagee by which he subjects the property mortgage to the satisfaction of the obligation secured through the sale of the property at public auction and the application of the proceeds thereof to the payment of his claim. Grounds for foreclosure. First, when the principal obligation is not paid when due, and second, when there is any violation of any condition, stipulation, or warranty by the mortgagor. Kinds of foreclosure. 1. Judicial foreclosure. Made through filing a petition in court. If the defendant fails to pay the amount due within the time directed by the court, the property shall be sold. The proceeds shall be distributed as follows: the costs of sale, claim of the person foreclosing the mortgage, claims of junior encumbrances in the order of their priority. Balance, after all of the above are paid, shall be paid to the mortgager or his agent. Extrajudicial foreclosure. A mortgage may be foreclosed extrajudicially where there is inserted in the contract a clause giving the mortgagee the power upon default if the debtor to foreclose the mortgage by an extrajudicial sale of the mortgage property. Redemption. Redemption may be defined as a transaction by which the mortgagor owner of the mortgage property reacquires or buys back the property within a certain period and for a certain amount after his default or after the foreclosure sale of the property for the satisfaction of the mortgage debt. Kinds of redemption. 1. Equity redemption. This refers to the right of the mortgagor to redeem the mortgage property after his default in the performance of his obligation but before the property is sold. In judicial foreclosure, the mortgagor is given not less than 90 days to pay the mortgage debt before the property is sold. In extrajudicial foreclosure, the mortgagor may avail himself of this right after his default but before the sale of the property. Right of redemption. This refers to the right of the mortgagor to repurchase the property within a certain period after it was sold for the payment of the mortgage debt. In judicial foreclosure, the mortgagor may redeem the property after the sale and before the confirmation by the court of the sale. In extrajudicial foreclosure, the mortgagor has 1 year from the date of the registration of the sale to redeem the property.
Now let's talk about antichresis. An antichresis is a contract whereby the creditor acquires the right to receive the fruits of an immovable of his debtor, with the obligation to apply them to the payment of the interest and thereafter to the principal of his credit. The word antichresis comes from the Greek word anti, which means against, and chresis, which means use, denoting the action of giving credit against the use of a property. An antichresis is first an accessory contract because it secures the performance of a principal obligation. Secondly, it is a formal contract because it must be in a specified form to be valid. The amount of the principal and the interest shall be specified in writing, otherwise it shall be void. But even if the antichresis is void, the principal obligation may still be valid. There are 4 requisites of an antichresis. First, that it be constituted to secure the fulfillment of a principal obligation. Second, the debtor be the absolute owner of the immovable property. Nonetheless, a third person not a party to the principal obligation may be the owner of the immovable given as security. Third, the debtor must have the free disposal of such immovable property, and in the absence thereof, that he be duly authorized for the purpose. Lastly, the amount of the principal and the interest be in writing, otherwise the antichresis is void.
The creditor has 2 obligations. Number 1, he is obliged to pay the taxes and charges upon estate unless there is stipulation to the contrary. If he fails to, he is required by law to pay for damages to the debtor. Number 2, he is obliged to apply the fruits after receiving them to the interest and thereafter to the principal. Measure of application of fruits. The fruits in a contract of antichresis shall be appraised at their actual market value at the time of the application. The fruits of the immovable may be applied to: Number 1, the taxes and charges upon the immovable. Number 2, the expenses for preservation and repair. Number 3, interest on the principal obligation. And number 4, the principal obligation. The debtor can reacquire enjoyment of property upon fulfillment of his obligation to the creditor, and when he is compelled by the creditor to enter into the enjoyment of the property unless there is stipulation to the contrary. This right is available to the creditor if he does not want to pay the taxes and incur the expenses necessary for the preservation and repair of the property. Effect of non-payment of the debt within the period agreed upon. The creditor does not acquire ownership of the immovable for non-payment of debt within the period agreed upon. Any stipulation to the contrary is void. In case of non-payment, the creditor shall have the following remedies. Number 1, to bring an action for specific performance. Number 2, to petition for the sale of the real property as in a foreclosure of mortgage under Rule 68 of the Rules of Court.